Major breaking news out of the United States District Court for the Southern District of Illinois. A major legal challenge has been brought against the so-called silencer or suppressor ban by the state of Illinois. This is a major lawsuit that will have implications rippling throughout the Second Amendment community, including potentially to the National Firearms Act. Stay tuned. Hey folks, I'm Mark Smith, host of the Four Boxes Down, a proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and New York Times bestselling author. If you haven't subscribed to the Four Boxes Down, our Second Amendment channel, please do so. Show your love for the right to keep and bear arms. Major breaking news, federal court, the United States District Court for the Southern District of Illinois, a lawsuit has been filed by the name Carlin Anderson versus Kwame Raoul, who is the Attorney General for the state of Illinois. This lawsuit is a huge deal because this looks to be a major challenge to declare Illinois state's suppressor ban or silencer ban to be unconstitutional under the Second Amendment and NYSERPA versus Bruin. Big deal here. I'll try to put a link to the complaint down below. I took a quick look on the docket. I did not see a judge assigned yet, so if a judge is assigned, I will put a link to it down below. But right now, the complaint has been filed. It is a challenge to the Illinois state suppressor ban. And basically, if you read the complaint, it sounds a whole lot like arguments that we've talked about on this channel, specifically that under the Second Amendment, you have a right to all bearable arms. That is not my definition. That is the definition of the United States Supreme Court in Heller, Catano, and, of course, Bruin. The complaint also goes on and argues that suppressors are, of course, in common use. The complaint says that over 2 million Americans own and possess using suppressors for all sorts of purposes, everything for hearing protection on the range to hunting protection for yourself and for other hunters nearby you. Also important for, firearm safety in training classes and the like. And as well, it's also in common use for the purposes of basically not being a nuisance to your neighbors, because for anybody that wants to shoot in your backyard or in a neighborhood, you know that often neighbors can complain about the noise. So you always got to be careful of that. And of course, in Europe, and this complaint actually talks about this, throughout Europe, it is common for people to use suppressors because it's considered rude with your neighbors if you don't use suppressors when you're firing in the backyard. So all of this is discussed in this major complaint, but the bottom line is the theories advanced as I see it seems very similar to arguments like the magazine argument and the like. Under the Illinois state statute, just to step back for a moment, let's talk about what it says. The Illinois state statute, which is they're arguing is unconstitutional. Illinois bans, quote, any device or attachment of any kind designed, used, or intended for use in silencing the report of a firearm. I should note, of course, and the complaint also makes this observation, that suppressors and silencers are often, synonyms. Silencers, of course, are famous from movies, but you know and I know that indeed firearms are not silenced by the use of a suppressor. It's just it makes it less noisy and less likely to blow out your eardrums. I should also mention that one of the other arguments made in this complaint, and I think this is a very important one, is that if somebody breaks into your home in the middle of the night, you may not have the opportunity to put on hearing protection if you need to, heaven forbid, use your firearm to defend yourself and your family. Well, at a high decibel, as you know, it could very easily damage your hearing or the hearing of your family members who are seeking to protect because the scumbag has broken into your home. One of the key things I found in this complaint that's quite interesting is in paragraph 25, it says the Supreme Court likewise defines arms, quote unquote arms, under the Second Amendment broadly with a general definition that includes, quote, modern instruments that facilitate armed self-defense, period, close quote. It also goes on to say that the U.S. Supreme Court has recognized, quote, armor of defense, which is historically considered within the definition of firearms. They cite to the Heller case as part of paragraph 25 of their complaint. And then what's also quite interesting, I did not know this, but you may have heard of the Maxim gun. I'm digressing just slightly here. The Maxim gun, of course, was a form of machine gun or something like a machine gun in the late 19th century, invented by Mr. Maxim. And it turns out his son, I did not know this, but his son actually applied for a suppressor permit in the year of our Lord, 1908. I did not know that the Maxim Guns Maxim had a son who was also interested in firearms technology. Just a kind of interesting side note, and he comes up in the context of this complaint because he had filed and got a patent for suppressors in the year 1908. Obviously, that's quite significant because, suppressor technology has been around for over 100 years. And, of course, the complaint points out that they're rarely used. What's quite interesting is that to support the proposition that silencers or suppressors are not really used in the commission of crime is they actually quote and rely upon testimony by the director or the interim director, I think he is, or one of the deputy directors. But bottom line is testimony from the ATF saying that suppressors are really not used for the purposes of commission of crimes. They're basically used by law-abiding people for lawful purposes. That's from the ATF itself. I think that's quite compelling evidence that that's true. But of course, as you know, under the Heller test, if an arm or something that's necessarily implicated with the use of arms is in common use for lawful purposes by Americans, it is protected. And this complaint alleges, and it sounds correct to me, that there's over 2 million people that use, silencers or suppressors in the United States, and that is certainly more than the 200,000 stun guns that were found to be in common use in the Caetano case in 2016. So to summarize where this case of Anderson versus Rayold stands, it looks to me that it's in a good jurisdiction, the United States District Court for the Southern District of Illinois. I don't think this is a terrible jurisdiction to bring a lawsuit like this in support of the Second Amendment. Only time will tell. We don't know who the judge is. When they're assigned, I'll let you know. Beyond that, remember, this is a challenge specifically to the Illinois ban on suppressors. And under the NFA, of course, suppressors are not banned, but you have to pay the tax and go through the NFA process to be able to possess a suppressor. But Illinois has outright banned them. So I find it's going to be quite interesting to see what a court says about suppressors and whether they're protected arms under the Second Amendment and how it's analyzed, which should be under the in common use test, because a precedent set here in the context of attacking the Illinois state ban on suppressors could ultimately be used to unhorse parts of the NFA, but only time will tell. Okay, hope you learned a little bit something here today about suppressors in this interesting case that just got filed in federal court in Illinois. I'll keep you abreast as things develop. And in the meantime, if you haven't subscribed, please do so. And we'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.